Thank you for your arguments. The next case is Chandler versus City of St. Cloud. Will you both be arguing, or is there just going to be one lawyer arguing?
No, Your Honor, there will just be one lawyer arguing. May it please the court?
Yes, sir.
Good morning, Your Honor. My name is Christopher Cosden, Wilbur Smith Law Firm in Fort Myers. I represent Mr. Chandler, who is the appellant here today, and the plaintiff below. With me at the table is co-counsel John Turacco. I would ask to save 5 minutes for rebuttal, please.
I've already set that for you, sir.
Thank you, Your Honor. Your Honor, this case arose when the plaintiff below, the appellant here, requested to see a visitor's log at the St. Cloud City.
That was December 13th, 2012. When did he file suit?
The action was filed, Your Honor, on 20 March of 2013.
So basically, he went in and asked for the visitor's log, and they told him it wasn't going to be available for at least 4 days. And then what happened between then and March 14th? Did he ever get it, or did he just not go back, or what?
Your Honor, I don't, apparently he got it at some point much later. I do not know, and the record does not reflect when he got it.
It doesn't allege in the complaint when he got it?
Sir?
It does not allege in the complaint that he had received the record at some point in time?
I don't believe he did, Your Honor.
Do you agree that the names of confidential informants are exempt from public record?
Under some circumstances, yes, Your Honor.
Do you think it was inappropriate to redact those names from the log?
There's no showing that there were any names of confidential informants in the log, and in fact, the trial court never reached the substance of the case at all.
Right, but I mean, is it unreasonable to say come back in 4 days, which includes a weekend, to give us a chance to review it for that exempt information?
I'm not sure that that's unreasonable.
Right.
But again, the trial court never reached that. We never got to the substance of the case.
I guess what Judge Lawson's getting at is what is the alleged violation of the public records law? The complaint seems to suggest that the statement by whoever was in the police department that we've got to look at it to see if there's any exemptions, and it won't be available until Monday or 4 days later. It seems to suggest that is a violation of the public records law.
Well, that is certainly what is suggested.
That's what
However,
that's the allegation in the complaint, right?
it is. Had the trial court reached that allegation,
We might reach that right now, is what I'm saying. Is, in other words, is it unlawful, is it a violation of the public records law to tell somebody who walks in off the street and asks for a record such as this that it's going to take 4 days before you can have it, so we can check it for exemptions and delete them? I would think that would be a tedious process to go through every name on a log and find out who that person is and whether they're a child victim or a confidential informant or somebody that is exempt from disclosure.
that could be, Your Honor, but the court received no evidence, and there is nothing in the record that suggests that was necessary or was indicated. I don't know, because the record does not reflect whether or not it would have been proper for the police to do that or not to do
Does
that.
the complaint on its face state a cause of action?
Yes, Your Honor, it does.
How so?
The complaint refers to 119.071A, which requires access to certain public records.
Under reasonable circumstances, within a reasonable time, with reasonable conditions, right?
Yes, Your Honor, that is correct. So the court appears to be asking me whether the conditions or the time or the circumstances were reasonable
I am, yeah.
without knowing what the facts were.
We're talking about as alleged in the complaint, the facts
Right.
as alleged in the complaint. If the facts as alleged in the complaint show nothing but a reasonable delay for a reasonable purpose, then why does the complaint even state a cause of action as a matter of law, I guess is the question.
Well, if that were the case, then presumably the city could have moved to dismiss the complaint for failure to state a cause of action, and that would have been heard by the trial court. That never happened. Had the city made that motion, then perhaps we would be here arguing about something else, or perhaps we wouldn't be here at all.
Counsel, you understand that our charge under the Constitution is that we only reverse when an error is one that is not harmless. So that's what we're getting at. In other words, do we send this back for a hearing on the merits? And is that really just an exercise in futility? Because on the merits, it appears that your client's complaint doesn't state a cause of action.
Well, Your Honor,
Doesn't the complaint have to allege the ultimate facts to set forth a basis for relief? And aren't those ultimate facts, doesn't he have to allege that they acted unreasonably?
Your Honor, the facts are set out at page 7 and 8 of the record, and the complaint states very specifically that the defendant's refusal to allow Chandler to inspect the public records violates Article 1, Section 24 of the Constitution and Section 119.071A Florida statutes. Now, whether or not that is true is, of course, an evidentiary question. If we had some evidence in the record that suggested that that was not the case, if the evidence were that Mr. Chandler's request was unreasonable, then the court might be justified in finding that that either the issue is moot or that the issue is not sufficiently material for the court to consider it. But that's not the issue upon which this case came to the court. We're here on
I have in my statement summary of the facts that on December 13th, there was a request for this record, and that the police said that it wouldn't be available for at least 4 days. Where does that come from? Is that set forth in the complaint?
Yes, Your Honor, it's
Okay.
page 7 of the record.
Okay, well, but you didn't read me the whole, you didn't read me that. You just said that there was an allegation that it was unlawful. So what I gleaned from the complaint itself is that your client's position was that the failure to deliver the record immediately upon his request is a violation of the public records law.
That
seems to be the gist of the complaint.
one could take the complaint in that way. Looking,
How else could one take the facts as alleged in the complaint?
well,
Because that's...
one could,
He doesn't say in the complaint that he came back on Monday and they didn't deliver it, and then he came back on Tuesday. I mean, he basically says he walked in and he asked for it. They told him he couldn't have it right away, and he thinks that that's a violation of the statute.
well, Your Honor, it probably is, because the visitor's log, by its very nature, is something that is available to the public. A visitor's log, and again, we don't have a copy of this, so I can't address it from the record, but ordinarily, a visitor's log is a list of names that's kept at a front desk where a person can write their name and perhaps the time and perhaps who they're going to see. And
Indicate why he wanted that, other than to conjure up a lawsuit?
it does not.
Isn't that basically what this is all about? This is an individual that knows the public records law and has filed numerous, I think they listed something like 9 lawsuits that this individual had filed, but he said there are many more. He even testified in the hearing that nobody has filed more lawsuits than him. So it really doesn't matter to him whether if he goes in and makes a request, whether their denial or their request for more time is reasonable. All he wants is a denial so he can file a lawsuit, declare indigent status, and attempt to settle the case and get his fees and expenses paid. Isn't that basically what this is all about?
No, Your Honor, it's not.
It's not?
No, Your Honor.
Okay, why did he go in and make the request? The record doesn't tell us, does it?
That is correct, Your Honor.
But he testified that what he does, and the only thing that he does, is to file lawsuits like this. He's a public records advocate. That's what he called himself, right?
Your Honor, being a public records advocate means to me that the person seeks to exercise his constitutional right to access to public records. Most people do not go and access public records on a regular basis. Some of us do.
Well, he does, certainly. I mean, that's what he basically does for a living, according to his testimony.
If he chooses to make his living doing something that the Constitution specifically allows him to do, we should not fault him for that.
The Constitution doesn't give him the right to declare indigent status so he can file these lawsuits without paying any fees, without properly declaring and accurately declaring what his assets are. And that's what this case is all about, isn't it? And
That's
he
what
didn't do
it-
that in this case, did he?
That's what the case is about. However,
He got caught failing to put down on his application the fact that he owned a homestead, when in fact he did. Isn't that basically what this is all about?
yes, Your Honor, and the statute specifically exempts the value of the homestead from consideration.
About fraud, misrepresentation here now. I'm going a little bit beyond what the complaint says and whether that states a cause of action. Because he testified in the hearing that the reason he didn't put it down was because there was a mortgage foreclosure action that had been filed and he wasn't paying the taxes on it. Isn't that basically right?
Yes, Your Honor, that's essentially
What he
correct.
didn't tell the court was, and what had to come from opposing counsel, was the fact that that mortgage foreclosure suit had been dismissed.
There was
He didn't
a,
bring that out, the other side did, right?
there was a dispute about the mortgage foreclosure, but the dispute has nothing to do with the finding by the court and nothing to do with the determination of indigence.
My question is, he testified that the reason he didn't put down on his application the fact that he owned his homestead is because he thought it was in foreclosure and he wasn't paying the taxes on it.
That-
When in fact, the state brought out the fact that that foreclosure suit had been dismissed and he'd been living in the house the whole time, right?
He had certainly been living in the house the whole time. There was some dispute in the trial court about the dismissal of the foreclosure action.
Well, show me where there was any mention by him of the fact that the lawsuit had been dismissed.
I don't believe he stated that the lawsuit had been dismissed. The city stated that the lawsuit had been dismissed. I don't know whether that's correct or not.
To dispute that, though, is there?
There's nothing in the record about the dismissal of...
Put that in the order, right?
apparently based upon the city attorney's statement to that effect.
And so, based on the fact that he misrepresented his assets in the application, why then didn't the court have the right on its own to say, I'm going to revoke his indigent status?
Because the statute, and I'm referring to 57.082, paragraph 2A2, specifically excludes the value of a person's homestead.
What difference does that make if the trial court finds that the questions are asked and he doesn't ask the questions truthfully, and it perpetrates a fraud by failing to disclose properly all of his assets, including his homestead.
Your Honor, to be...
And based on that, doesn't the trial court have the discretion to say, I'm revoking his indigent status? He has to pay the filing fee, and if he doesn't, the case is dismissed.
Your Honor, in a case called Lance versus Wade, which is cited in the brief, the Florida Supreme Court told us that the basis for a fraud must be a false statement concerning a material fact.
Well, the
Quoting from
material
Wade.
fact is assets that you have and that you're supposed to list on the application. If it wasn't material, then he should have objected and asked that be deleted from the application. He didn't do that. He just answered falsely.
Your Honor, the statute specifically excludes the value of a person's homestead from consideration. Since the
That
value...
doesn't mean that you are, does that mean that you're allowed to lie on the application, say, I don't have a homestead, and that's okay?
Yes, Your Honor, that's exactly what that means.
Okay. The application asks you what your assets are, do you own a homestead, and you say no, and you answer no, knowing that it's false, under penalties of perjury, I assume, because you have to answer based on the best of my knowledge and belief, and you say it's okay to lie like that on the application.
Your Honor, you're asking now about the sufficiency of the
Is it okay to
oath.
lie like that on the application? Is it proper to lie like that on the application?
Your Honor, it is not proper to lie to a court anytime. However, in this situation,
You just said that because homestead is not calculated in indigent status, it doesn't really matter how he answers it on the application. He can answer it falsely, and that's fine. Are you retreating from that statement that you made earlier?
Your Honor, what I'm trying to express to the court
Go ahead.
is that the statute excludes the value of a person's property from consideration. The statute does not allow the court to consider the value of a person's homestead. To be fraud...
Why is it asked on the application at all then? Or why does it ask you to list your assets? Why didn't it just say exclude homestead?
The application asks for a number of items that are relevant and material. I do not know why whomever drafted this form put homestead on it.
Are you saying that it's okay to lie about those things on the application that are considered not relevant? But you have to answer what is considered relevant truthfully. And that there are no consequences for that false information.
That is essentially what the Florida Supreme Court told us in Lance. False statement concerning a material fact. If the fact is not material...
The trial judge ruled in favor of your client on the fraud issue, right?
He did, Your Honor.
Right, so we're here on the trial judge's alternative ground, right?
The trial court did find that there was fraud because he cited in the order that we're reviewing a statute that says if the trial court finds fraud and misrepresentation, reports it to the state attorney's office. And that's exactly what happened in this case. The issue is he reported it to the wrong state attorney's office. So the trial court, I think, is saying there was some fraud in the suit. He just elected not to dismiss the suit on that basis, but to revoke his indigent status, right?
Your Honor, I think there are three questions there, and there are several errors. The first error made by the trial court is that the statute provides that the court must find the defendant not indigent in order to dismiss or to reject the application for indigence. Again, that's in the statute, paragraph 7A. The court never made a finding that the defendant is not indigent. Excuse me. The court did find that in the order of 12 June.
I'm not sure that you're reading the statute correctly, subsection 7. I mean,
Your Honor, the last...
It says that if he finds that the person is not indigent, the court shall revoke. But then it says, upon learning of discrepancies between the application and the actual factual status, which is what he found here, the court shall determine whether the status and any relief provided as a result of that status shall be revoked. I mean, it doesn't at least plainly say you have to be found indigent to have the status revoked. It says if there's a discrepancy, you determine whether relief provided as a result of the status should be revoked. Those seem to be different things to me.
Well, that sentence seems to require the court to make two determinations. First, if the person has been found indigent, then the court shall determine the status. In other words, the court shall determine if the person is indigent or not indigent, and shall determine whether any relief provided as the result of the status, in this case not paying the filing fee, should be revoked. Okay?
Based on the discrepancy found, I mean, that's,
Yes.
should you revoke the status?
He's
based on
used
the
up his rebuttal time. Did you wish to follow up any
That's
further? Okay, I'm going to give you another minute of rebuttal time, sir.
Thank you, Your Honor.
Your time is exhausted, though. So you'll have 1 minute of rebuttal, Counselor.
Thank you, Your Honor.
Yes, sir.
Your Honors, may it please the Court, Sherry Hopkins with the firm of Bell and Roper. I represent the City of St. Cloud in this matter. You are absolutely correct that the public records matter should have not even made it as far as it did. However, we're here today. The appeal is strictly related to the indigent status of the appellant that was revoked by Judge Jordan in accordance...
What was the allegations of the complaint?
That the City of St. Cloud had refused to give the visitor's log to Mr. Chandler, when in fact they actually stated to Mr. Chandler that they would provide the log, but they needed to review...
Is that in the record? Because I think that's kind of important.
It's actually probably not provided in the record other than through our answer
Well, the
that we
complaint's in
filed.
the record, isn't it?
The complaint isn't, it's in our answer.
Your answer's in the
Yes.
record, isn't it?
Our answer's in the
So it's
record.
alleged in your answer.
In our answer, yes, sir. And it is also shown through the email exchange that occurred, that was attached to our answer, that occurred with the City of St. Cloud, where the individual who was the public records custodian actually forwarded the request to the officer that was in charge of reviewing the visitor's log to make certain that the proper things were redacted if there were confidential informants, if there were victims of crimes that were listed that need to be redacted. And all of that information is in fact contained in our answer. The matter, though, before this court is related to indigent status of the appellant that was revoked by Judge Jordan during the hearing on the city's motion to dismiss the case with prejudice for the inconsistencies that were provided between the actual financial status of the appellant and his application. The court applied Florida statutes section 57.082 correctly. He applied subsection 7, which does in fact have two parts to it. There's a discretionary part, if you will, and a rather non-discretionary part. The first part says that if discrepancies are found between the actual financial status and the application, that the court is to consider the information provided and determine whether, in fact, the indigent status and any provisions provided or relief provided as a result of that indigent status need to be revoked. That's the first part, that's within the court's discretion, and that's what Judge Jordan acted within here. There is a second part to that subsection, and this is the rather non-discretionary part that says that the person may be heard from. And if the person is heard from, and the court determines that they are not indigent, then the court shall revoke the indigent status. We don't have that situation here. Judge Jordan did not make a determination that the appellant was not indigent.
Well, he claims that he didn't really know that this was going to be an issue when he appeared at the hearing. And so he subsequently filed everything under the federal guidelines to show that he's indigent. So what's your response to that?
Well, I think he did have notice of what could happen. As a matter of fact, all of the discrepancies were pointed out in the motion. He testified at the hearing to the fact that he only hired an attorney due to the discrepancies and the things that were indicated in the city's motion, because he had no knowledge of that. His knowledge was limited to public records. He testified regarding the severity of the discrepancies. His counsel appeared at the hearing. His counsel filed a memorandum the day of the hearing that actually cited to Florida statutes section 57.082. Had he read section 7, he would have understood and should have understood.
The court, trial court, or the clerk have the right to review indigency status on its own and make a determination without conducting subsequent hearings if it has the proper records before it.
The clerk makes that initial determination.
Does the clerk have the right to go back and redetermine that if the clerk comes up with some additional information? Or does the clerk have to refer it to the court and have to have a hearing?
I actually think...
The court still have the authority to review the status, and if the clerk found a mistake or discrepancy, that the clerk could revoke the status without having a full-blown hearing to do it.
I think if the clerk's duties are ministerial and they are limited to what's provided to them, so I don't know that the clerk can do much of a review outside of what's provided to them. I think that the review comes in two ways. If the person is found...
The clerk made the review and then goes back and discovered that there was a discrepancy. Does the clerk have the power to change that? Or not? You have to set a hearing and...
I don't believe that the clerk does by itself have that ability.
Right. So a hearing is required, right?
To revoke an indigent status based on non-indigence? Yes, but now if the clerk, I believe, if the clerk found something that was inconsistent that the city found and brought it to the court's attention, I believe that the court can take that under advisement and look into it and make a determination regarding whether that inconsistent information is enough to revoke the indigent status, strictly because the inconsistent information was provided. However, if the court hears from the individual, they are permitted then to revoke the indigent status if they find that the person is not indigent. And I think that that's precisely what we have here, that the court, within his discretion, within that initial discretionary part of Florida statute section 57.082(7)A, Judge Jordan acted within that discretion and considered all the information. He didn't have to hear from the appellant, but he in fact did hear from the appellant, and when he heard from the appellant, he was able to verify the inconsistencies.
Before, if the clerk or the trial court comes upon information that they discover, based on what they have before them in the records, that there was a mistake and there was a discrepancy, you said the clerk couldn't, but the trial court would have the authority to revoke indigency status without conducting a full-blown hearing and giving an opportunity to be heard. Is that basically right?
Yes, sir.
Right.
And I think in this instance, the appellant was given more than what he was entitled to receive, because the court did hear from him, and the court verified, in fact, that all of the things that were pointed out in the city's application he verified that they were in fact discrepancies, and there was no valid reason given for why the discrepancies were in the record, why he in fact answered the way that he did in his application. Regardless of whether there was at one time a foreclosure, there is nothing in Florida statute section 57.082 that enables a person to not answer the question about their homestead status or their ownership of a home.
The council seems to indicate or argue that you have to answer the material questions. I guess who determines what's material, I'm not exactly sure, but you have to answer those questions correctly and truthfully. If the questions aren't material, it can't constitute fraud sufficient to set aside the status or to dismiss the lawsuit.
And I'm sorry, but I find that a little bit laughable, because I don't think that there is anything in the statute that says this discrepancy is minor enough.
Your theory was not, your motion was for fraud on the court.
Absolutely.
And a fraud on the court, you have to prove a material omission, right?
And the court denied my motion for fraud on the court and said that there wasn't fraud.
So the hearing was over, right?
That's exactly right.
He announced his oral ruling.
Yes.
And during his, in between the time of the oral ruling and the time of signing the order, the judge went back and revisited 57.082 and came up with a new theory for revoking indigent status, right?
Correct.
But the city hadn't asked for that relief.
No, Your Honor.
Okay. So the question is, does he have a right to be heard on that before the court makes that determination?
And I believe he was.
Well, he only had a right, he only was on notice of what the city was alleging and was asking for. He wasn't on notice of a different theory, right?
I believe he actually was on notice, because he cited to the very statute that the court revoked his indigent status under in his memorandum in opposition.
But it's relevant, the statute is relevant to the extent that it shows that the omission was not a material one, right?
Well, I think
we're talking about the materiality of the omission. The omission was not a material one, right? You agree with that, right?
No, I don't agree with that. And the reason I don't agree with that is because he's misreading subsection 2 of Florida statutes, section 57.082. Subsection 2 just says when there is a determination of non-indigent status, that homestead property is not to be considered. If there is if we are looking strictly at whether the person is indigent, you can't consider their homesteaded property in that. You can consider.
Why is the question even on the application then?
Because it's relevant. Because if
Why is it
you...
relevant if you can't consider it?
No, you can consider it, is my point. You can't consider it when you are strictly looking at what that particular statute says.
That's all the clerk looks at, is the person indigent, right?
Yes, but...
And the judge never looks at it unless there's a question about that determination. So why is the question even on there?
Because subsection 2, when it's discussing the determination of the clerk, it talks about a presumption of non-indigence. Not related to indigence, it's a presumption of non-indigence. And it's saying when you are looking, clerk, at all of the ownership of property and assets, you can't consider their homesteaded property when you're presuming that they aren't indigent. However, you can consider their homesteaded property along with everything else, but you can't make a presumption that they aren't indigent just because they own a home.
Why would you ever presume that they aren't indigent because they own a home?
Well, that's what the statute is making clear. You can consider all of their real property except for their home when you're making up, if you are presuming that they are not indigent, it can't be strictly because they own a home. And that's what the statute is saying. It's related to the presumption of non-indigence. And subsection 1 then provides all of the information that you are to provide in your application, and at a minimum, you are to provide your real estate interests. And then on the application itself, it requires you to list your homesteaded property and your non-homesteaded property, and it breaks it out separately because of that, the fact that you're not allowed to make the presumption of non-indigence by ownership of property. They didn't want to lump the homestead together with the non-homesteaded property, so it's separated out. But it doesn't say you can't consider it when you're determining whether a person is indigent or not. That would be a person owns $1 million home free and clear with no liabilities, but because they make a low income, that they're indigent. And I think that the clerk has to be able to consider that. And in this particular situation, the appellant didn't give the clerk the ability to consider any of that stuff because he decided on his own not to include it. And he doesn't have that right. The statute is clear. He's supposed to provide the information of ownership, the information related to his mortgages, the information related to any liens or judgments. He didn't do any of that. He decided on his own that he didn't need to. I think just one final thought that I would have for you is that Judge Jordan is in the best position to evaluate all of this information. He went above and beyond what the statute required of him. He evaluated the application. He evaluated the information that was provided in the public records showing the ownership of the property, the mortgages. He actually considered the fact that there was a foreclosure action. There was no testimony to refute the fact that the foreclosure action did exist, and it did exist. It had been 2 years prior to the application that the foreclosure action was dismissed, and there was nothing provided by the appellant to indicate otherwise in the record. Judge Jordan acted within his discretion by the statute. He then provided the appellant with the ability to pay the filing fee. He didn't dismiss the case right away. He gave him the ability to pay the filing fee. The appellant chose not to pay the filing fee, and then within his discretion to control the litigants and the decorum of his courtroom, he dismissed the case for non-payment of the filing fee. Judge Jordan acted within his discretion, and both of his orders should go undisrupted by this court.
Okay, thank you, counsel. All right, I'm going to give you a minute, sir.
Thank you, Your
sure it's
Honor.
48 seconds. I'm going to start the clock in 12 seconds.
Thank you,
Go
Your
ahead.
Honor. Counsel argues that Mr. Chandler should have provided information regarding mortgages, liens, and judgments on his homestead. Of course, those are not asked for on the application for determination of indigent status. The court asked whether the clerk can later review a prior indigent determination. No, there's nothing in the statute that would allow that. A hearing is required under Section 7A. Of course, if the hearing is required, the litigant must be afforded due process, notice, and an opportunity to be heard. That did not happen in this case. The other point that counsel tries to make is that Section 2A2 would allow consideration of the value of the homestead. Now, had the court considered the value of the homestead in Mr. Chandler's testimony, the court would have found that Mr. Chandler was more indigent than, in fact, he was, not less indigent. Therefore, I would ask the court to reverse the determination of the trial court and to send this case back for substantive determination.
You concur that the information about the fact that they had told him, we can't give it to you now, but come back, let us go through and redact all the information, that you really shouldn't have, and then come back and they give it to you. It's contained in their answer to the complaint. If that
I'm sorry, Your Honor.
those allegations are contained in their answer to the complaint.
Your Honor, that would require a factual determination by the trial court since,
No, I'm just asking, are those allegations contained? I mean, do you concur that those allegations are contained in their answer to the complaint? She said they are.
there is certainly a conflict of fact that's raised by the answer to the complaint. However, had the trial court looked at that, the trial court would have found that the visitor's log, that document, is something that's available to the public, and since it's already available to the public, redactions are not
I
required.
just wanted to know whether you conceded that they had made those allegations in the answer, that's all. I'll go back and look at the answer myself.
All right, thank you. Thank you
Thank
all
you.
for your arguments.